Good afternoon. My name is Angus Wilson. I'm an associate here with Semfir Tamarkin LLP. I've been with the Vancouver office for about 3 years at this point. Prior to joining the firm, I worked at the BC Employment Standards branch as an investigator, so I've got some good inside lines on how that applies. If you have any questions at all, drop them in the chat. I'm happy to answer. So one that had come in before we started here was, obviously there's a lot going on in the news about people losing their jobs as a result of things that they've posted online. Interesting times we're living in, but the main question is, can your employer fire you for something that you've posted online? Some opinion you've made public, or sometimes it's anonymous, but your employer finds out anyways. It depends is always the answer. Basically, your employer in most circumstances can terminate you for just about any reason, but they do need to pay you severance. So that's what we're working with. Do they have just cause to terminate you? Usually it's a really tough burden for them to meet. And you should always consider speaking with an employment lawyer before you sign anything, before you say anything to your employer, to know where you stand. So if this has happened to anyone here in the chat, let me know. I'm happy to talk a little bit more about that. Also in the news, Fiverr International. Oh, here we are. Okay, I've got a message from Nina here on YouTube. Hello, I was recently told by my employer that they are going to be moving me to a new position. I think it's technically a demotion. What can I do about this? Well, you're not obligated to accept new terms of employment. So it really depends on what the changes are they're looking to make. Are you reporting to a new person? Is it lateral? Is it a true demotion? I'll need a little bit more information to say for certain, but in circumstances where your employer tries to make a unilateral change to your employment, that can be a constructive dismissal. And what that means is you can treat your employment as being at an end. You can seek severance. And I would always recommend that you get in touch with our intake team to set up a consultation about that, because it's really a super fact-specific determination as to whether or not you've got a good claim for it. So before you take any steps, before you accept that new position, I would say get in touch with our team, and we'll be able to provide you some more specific information on that. All right, I've got a question from Jackson from Reddit. I'm a salaried worker at 40 hours a week. I recently had to miss a day of work for a funeral. However, I made up most of my time by working early and leaving late. I am only short about an hour from my next pay, but my employer is deducting 8 hours of unpaid time off. That's an issue. So there's a few things you can do in this circumstance. One of them is to essentially educate your employer on what the Employment Standards Act says. First and foremost, you're going to want to, it depends who the funeral was for. If it's for immediate family, you may be entitled to bereavement leave, which means you're not taking vacation time or anything like that. By working extra, coming in early, coming in late, you may have also engaged overtime provisions of the Employment Standards Act, even as a salaried worker. So you can file an Employment Standards Branch complaint if your employer isn't making this right, if you will. They also can't take any steps against you if you do file an employment standards complaint, such as discipline, cutting hours, et cetera, et cetera. So in terms of how is this possible? Well, employers make mistakes all the time. They should know the law, but they often don't. And in this case, it might be a mistake. It might not be. It might be them trying to take advantage of you. And certainly reach out to our intake team to set up a consultation. But generally speaking, anything to do with wages, time off, you can get that dealt with in probably, I'm not going to say it's quick, but it's effective through the Employment Standards branch. Oh, Jackson, I see that question came through our YouTube as well. Feel free to drop any additional details, either Nina or Jackson, in the chat if you want me to get a little bit deeper into those. Okay, Jillian from YouTube says, I'm working remotely for a repo company in the United States. They've told us that we don't receive Canadian holidays and that our contracts are based on the laws of their state. How much of this is true? None of it if you're a BC employee or an Ontario employee, as it may be. I'm based here in BC. So the BC Employment Standards Act applies. Any province that you're located in, that you perform the work in, that is going to be where the Employment Standards Act in your jurisdiction applies. So that deals with things like statutory holiday pay, vacation pay, protected leaves, hours of overtime. Those vary a little bit between provinces. So yeah, the take home of that, Jillian, is just that none of that is true. Their laws as a US company do not apply to your employment. They're misinformed. Question, follow-up from Jillian there. If you're not getting the same overtime considerations as your Canadian employees based in BC, file an Employment Standards Branch complaint. You can basically get up to a year's worth of unpaid wages through the ESB. It's free to file. It takes a little bit of time for them to work through the queue. When I was there, it was a really, really long wait, and they've done a heroic effort to get it down to size a bit. But you're probably looking at about a 5 or 6 month wait for the investigation. So file a complaint. You can do so kind of at any time, but you want to stop that clock so you can get more wages. And ultimately, that is where you go to enforce it. If you've already tried to discuss this with your employer, they're not having any of it, they're wrong. And ultimately, the ESB is the place to go to deal with that kind of situation. As a sort of follow-on from that, they cannot terminate your employment for filing an ESB complaint. If they do that, contact us immediately. That's just, jumping a few steps ahead there, but you do have rights in BC. They generally exceed what any American counterparts might have. So keep that in mind and stick to your guns. I've got a question from Mo from YouTube. My manager is being unfair and unreasonable with me. They gave me 2 write-ups for being just 5 minutes late twice in my whole career, just because they don't like me. So it's clear they're basically trying to get rid of me. Can I get EI if I'm terminated or file a labor law complaint? Yeah, so Mo, there's a number of different things to do with that. Generally speaking, employers need to provide you notice or pay in lieu of notice if they're terminating you without cause. For absenteeism or lateness, there needs to be a very specific set of steps that the employer takes. They need to give you warnings, time to improve, and it really needs to be clear that there's no improvement happening. If after all that, they may be able to make out just cause, but it is really a steep burden on their part. I started with just cause, but I'm getting to your EI question. EI is even harder for them to prove because they need to show that there was actual misconduct on your part. Almost in no circumstances will EI deny you because of being terminated for lateness. And if you're fired for absenteeism, absolutely get in touch with our intake team to set up a consultation, because we'll be able to walk through in much closer detail what happened and whether you're entitled to severance. Next question from Neil P on YouTube. What is the best way to deal with harassment in the workplace? I have a new manager. She's very aggressive and has made a number of racist comments. I'm getting very uncomfortable, but I am worried that I will get fired if I complain. Neil, that's a great question. What we're working with workplace harassment and racist comments, employment law is a complicated area. We've got, in this question alone, we've got both workers' compensation, so that's WorkSafe BC, and potentially the BC Human Rights Tribunal as well. So when we're talking about ongoing harassment, you're still in your job. There's this idea that HR is not your friend. Well, it kind of depends on the situation. So HR is fundamentally there to protect the employer from things like lawsuits, complaints. They're there to deal with those complaints when they arise. And once you've made that complaint, you triggered the employer's obligation to do something about it. Until you make that complaint, there's basically this defense that they can raise that says, we didn't know about this. This was just this manager doing what this manager was doing, and nobody ever brought it to our attention. So in terms of that, you certainly can and should raise it. They should be investigating it, and you can't be terminated for raising a workplace harassment complaint. If they do terminate you, that could be something called a prohibited action, and that's something that our office assists people with filing those complaints with WorkSafe BC. You've got a year after that to deal with it. So certainly, if you're ever terminated, get in touch with us as soon as you can. You can go to employmentlawyer.ca, as we've got right here, to connect with our intake team. Okay. I've got a new question from Reddit from Xavier. I received a payback clause for education training that would require me to work 3 more years to have it 100% paid off, even though it's for my trade and required for me to work. Is there any way of getting out of it? If I left now, I did 3 levels, which would cost me $20,000 in total. But the company has very much gone way downhill. I suppose my first question would just be what you mean by the company going downhill. I mean, if the company is no longer going to exist in a couple of years' time or a couple of months' time, that kind of depends on whether or not they're still going to be a viable business. That's more practical, just in the sense that if they're no longer a business, they're not necessarily looking to make good on debt. But essentially with those clawback clauses, if you will, it comes down to why those funds were advanced. And if the company has paid off development and training for the purpose of, having you be a better employee for them, and then you do leave, sorry for saying this, it depends on the contract. It depends on the circumstances that you're leaving in. If you're terminated from that employment, it may not apply. They may waive it. If you resign and go to work for one of their competitors, they may try to claim that back. Really, what you're going to be looking at is what it says in your contract. If there are clauses specifically that deal with withholding wages, you're sort of pre-authorizing them to take that out of your pay. You may run into an issue with them withholding your final paycheck or any sort of compensation for length of service or anything like that at the end of it. But I unfortunately can't give you much more information without seeing the agreement. So I would certainly say read it closely and perhaps have one of us read it by going to employmentlawyer.ca and getting in touch with our intake team. Okay. I've got a question from Mina on YouTube. My sister is currently off on maternity leave. She was in training to move to a senior position before leaving, but now she's in talks to come back, and it seems to be nowhere on the table. Can they just revoke her promotion while she is on maternity leave? No. If it's a promotion that she had signed and it was agreed by the parties that she'd be coming back into this new role, they can't just take that away and sort of yoink it at the last minute. Under the Employment Standards Act, and yeah, I'm going to get into both the ESA and Human Rights Code in this. The Employment Standards Act protects employment during maternity leave. It protects the conditions of employment. So I've encountered situations where people will come back from a maternity leave and they're told, sorry, your position doesn't exist, or sorry, we're keeping your replacement. Definitely worth reaching out to me or any one of our intake team, because that is a violation of the Employment Standards Act. You've got Section 54, which deals with protected leaves. So that's maternity or parental leave, jury duty, reservist, like the list goes on and on for job protected leaves. And if your employer does anything to change the terms of your employment while you're on one of those leaves or terminates you, you're entitled to compensation. This is something we do on the regular, get people paid because their employer does this kind of thing. So certainly have her reach out. That is definitely worth getting some more specific information on, more specific than I can get on a call like this. But yeah, please do reach out. My contact information is up in the corner there. Okay, I've got a Facebook question from Jack. Terminated for no cause due to downsizing, 10 years in sales role. Contract limits severance to the BC Employment Standards Act, but doesn't mention waiving of the common law. Okay, so this is a good question. It's a complicated answer, so bear with me for a second. Basically, with contractual interpretation, sorry, I'll start from the ground floor. Generally speaking, if there's an enforceable contract that limits you to the ESA, courts uphold that and they say you're limited to the ESA. But there are a bunch of ways that employers mess that up. They mess up sometimes how the contract was executed. So if they've got an agreement that would otherwise be enforceable, but they had made an offer to you in an email before you started the role, and then first day of work, they put this agreement in front of you, that's often unenforceable unless they give you some sort of a fresh benefit for signing it. Other ways, if it's a clause that tries to contract out of the ESA or can be argued that it contracts out of the ESA, courts will set that aside in favor of common law reasonable notice. Really, we need to have a look at that contract. With 10 years in sales, you could be looking at 8 to 12 months, depending on what that, depending on what your sales role is, because industry does matter in terms of how likely you are to find new work. And we'll really be able to dig into what the facts surrounding that contract are, whether the clause itself is enforceable, and if it's not, we'll talk about how to make good on that. So thanks for the question, Jack. Jacob, I haven't heard about the mass terminations at Lufthansa. I'll have to look into it. But just a bit on mass terminations. It really depends on whether your job. Sorry, I'm not sure if it's your job. Lufthansa as an airline could be federally regulated as an employer, which means you're not looking at the BC legislation, so the BC Employment Standards Act. You'd be looking at the Canada Labour Code, which is different piece of legislation, a lot more robust in terms of the protections for workers. But both of those have provisions for mass terminations that are over and above what you'd normally get if you're one employee who loses their job. I wish the best for the people at Lufthansa in touch. And if there's any of them on this call, I'd say reach out to employmentlawyer.ca. And 300 jobs gone, moving to the Philippines. Okay, well, certainly get in touch. ESA Ontario. Okay. Well, good to know. I practice in BC. Ontario is a bit of a different animal, and we do have another call coming up on the 22nd. So that'll be Luke Serta, who's a managing partner of our Alberta office. He started out in Ontario. So I would certainly say reach out to our intake team, set up a consultation for yourself. And certainly anyone that has any questions about their employment rights, get in touch with us. We're always happy to talk employment law. It's what we do. The ESA side of things, I would definitely say if you are federally regulated, it could open up some new doors for you as well. And that's something that our Ontario-based intake team and our Ontario-based lawyers will be able to evaluate over the course of a consultation. Mina, thanks for the message on that. I will look forward to getting something from her. Follow-up question from Nina just before I go down to Carmen here. One more question. If my pay is lower with this change, does that mean there's enough to be a problem? Yeah. So generally speaking, with a constructive dismissal claim where you get to treat your employment as at an end, factors like demotion, title change, and compensation, those are all factors that apply. One of the easiest kinds of constructive dismissal claim to prove is a reduction in compensation. So if your pay is reduced by a third, well, a third is high. If it's 20%, if it's 15%, that's going to be a significant change to your employment, and certainly something that is worth a further discussion. At that point, they're changing a major part of your employment, which is to work for a set amount of money. And if they're starting to change those terms around, you definitely want to get advised on whether or not that's a constructive dismissal and ultimately what steps you can take. Okay, I've got a question from Carmen Nixon from Facebook. What is going on with the HRTO? I've been waiting for my case filed in 2019 to get a hearing date. Yeah, I wish I had a better answer and better news for you, Carmen. Unfortunately, kind of all across the country, human rights tribunals, courts, everything is really, really backed up. There are times where we'll have a date set, we'll show up in court all ready to go, and there's no judge to hear it. So, like, quite frankly, we need more judges. We need the human rights tribunals to have more adjudicators, and it all comes down to staffing. Unfortunately, that is kind of what we're working with. 2019 is a long time. In BC, we're backed up 3 years, I want to say. So 2019, hopefully it's soon. I hope for you. And it can't hurt to reach out to them and get a status update. Sometimes things do fall through the cracks. And if you haven't heard anything for a while, certainly do reach out to the HRTO and see if you can get an update. Okay, I've got a question from Lynn on YouTube. This one deals with independent contractors rather than employees. So, do I have any sort of protection as a contract worker if my employer chooses not to renew my contract when it's up for the year. They've been dropping staff lately, and I am worried. So if you're a contractor who does work for the same organization year after year, it's been going on for a while, if they're, the majority of your contract income, you are still entitled to notice of termination. If they haven't provided you that notice of termination, then, well, they should, and you could have a claim for wrongful dismissal even as a contractor. So keep an eye out. If there's something in your contract that deals with notice and you're a true contractor, you can uphold the terms of that agreement. On the other hand, and this is a really important one, you may be misclassified as a contractor. Even if you have a GST number, even if you submit your own taxes, a lot of employers will use that idea of an independent contractor to get around things like workers' compensation premiums, certain tax benefits and things like that. Contact us at employmentlawyer.ca if it looks like they're not going to renew it. We're always happy to have a discussion about what your rights and entitlements might be. At this point, yeah, you do have protections, and we can help you make good on those. They're not the same protections as an employee, but you might be an employee and just not know it. We'll be able to help with that. Okay, the next question is from Anthony on Facebook. I've been working at my job for nearly 6 months, and my initial 3-month probation period ended in June. I made a mistake during that probation period by missing a federal tax payment, which our accountant also failed to catch. And now my boss is putting me, quote unquote, back on probation for 3 months because of it. I'm questioning whether it's legal to reinstate probation after it ended, especially over a past mistake, and whether my employer can legally reduce my salary during this probation period. So I'll start with that last one. No, they can't reduce your salary. When it comes to sort of putting back on probation, it kind of depends on what they meant by that. With terminations, they can happen at almost any time for just about any reason, as long as they provide you notice. And now that you're out of that 3-month probation period, you're no longer a probationary employee under employment standards legislation or the common law. So if they terminate you at this point, you're entitled to compensation. We can help you get it. And if they do reduce your salary during this new probation period, they can't do it. Get in touch with us as soon as you can if that does end up happening, and we'll be able to walk you through step by step what you want to do. Just looking at the time, I've got time for a couple more questions here, but after about 1:30, I will just let you know that Monday, September 22nd at 1:30 Mountain Time, because he's our guy on the other side of the Rockies, Luke Serta. He'll be here and back to answer all your questions. He practices in all 3 jurisdictions that we're in as well. So if there's any Ontario or Alberta specific questions, he may be able to give you a bit more information on that. So we've got a question from Fresh on YouTube. When it comes to positions that don't qualify for traditional overtime, what is the limit on that? Like, how much can they abuse that category before it's a problem? There are certain circumstances where overtime doesn't apply. It's really, really quite limited in terms of when they can't pay you any sort of compensation for it. Managerial employees tend to not be entitled to specific parts of the overtime provisions of the Employment Standards Act. That's set out in Section 40, but that's the time and a half. That's double time. Now, at the same time, they are entitled to be paid for all hours worked. So if you're a managerial employee who is working at an hourly rate and they cap you at a certain amount, and they say you don't get paid for any hours over 40, even if you're working 50, 60-hour weeks sometimes. That's definitely a problem. You're entitled to be paid for the time that you work. There are some contracts where it'll be, you're earning very good money, and it says expressly in that contract you are going to be working longer hours as the business needs, and this salary is for all hours worked. It depends. I know, awful lawyer word there. But in many circumstances, employers will kind of use that as a blanket to get out of paying their people properly. In that case, certainly get in touch with us. Get in touch with your employment standards branch in the province that you're in. BC Employment Standards branch here for any sort of wage complaints, and employmentlawyer.ca. I've got one final question from Lynn as a follow-up. If you feel like an employee and you're paid like an employee, and the only thing that happens is the taxes and them calling you a contractor, you're probably an employee. In terms of paid holidays and sick days, that's a big one. In terms of that sort of contractor relationship, if you are an employee, it's likely that you're owed a fair bit of holiday pay, vacation pay, and that goes back a while. Sick days, yeah, the whole 9 yards. If you're actually an employee and you've been paid as a contractor, definitely worth investigating. And we can certainly help walk you through that. So hopefully this has been helpful for everyone. If you've enjoyed today's session, subscribe, tune in for the next one with Luke Serta on the 22nd. And if you have any further questions, feel free to contact our intake team through employmentlawyer.ca. We also have a severance calculator at pocketemploymentlawyer.ca, which even if you didn't lose your job, just see what it could do for you. Fun tool to play around with. Anyways, thank you all, and I hope this has been helpful. Bye for now.